Aimee, if you don't mind sharing, that would be lovely.
Wonderful. We're getting there. Just give me a hot second. I need to get this. Sorry about this, guys.
No problem.
Let's see. Let's just do this. Yeah. Let's do Okay, let's just do that. Are we good? Yes.
Good. This is beautiful. We're going to call this meeting to order now. It is 6:32 on September 15th, 2022, and this is a public meeting of the City of Portland Police Accountability Commission. I'm Dr. Christine Moses, along with Aimee Nixie, and we are your facilitators for this evening. If the Spanish language interpreters, and Thalia, can please give us the information on Spanish language interpretation, that would be lovely.
Buenas tardes, buenas noches. Son las 6:33 de la noche del día noviembre 15, jueves del 2022. Esta es una reunión pública de la Comisión de Responsabilidad Policial de la Ciudad de Portland y vamos a comenzar. Esta reunión va a ser grabada.
Thank you so very much. The city also offers ASL interpretation, which is being provided by Andrea and Amanda. You can pin their video feed if that is helpful to you. Finally, the closed captioning is turned on in Zoom as another means of assistance. But please note that this is an automatic captioning service and it is not always accurate. The city supports access to meetings of the Police Accountability Commission and can provide other language support as well. Please email in advance of future public meetings, either as a response to a public meeting notice or directly to policeaccountability@portlandoregon.gov to ask for other assistance, including interpretation into other languages. This is a public meeting subject to City of Portland Administrative Code and Oregon State Law and is being recorded. For this meeting, the chat function is enabled for commission members to communicate with each other. Members of the public will be able to ask questions using Zoom's Q&A feature. As the commissioners are presenting and/or discussing things, if attendees have questions, please feel free to submit them through the Q&A. We hope to use this feature to help guide our conversation during the meeting and future meetings and agenda topics. I'd like to be clear that not all questions will be answered during the meeting, but if answered, both the questions and the answer will be visible to you and will become part of the meeting record. To access this feature, just click on the Q&A icon in the middle of your screen. Also, I would like to turn the land acknowledgement over to our co-chairs.
Hi, good evening, everyone. My name is Faith Aiken. I want to take a moment to acknowledge that although the city has asked for a moratorium on offering land acknowledgements, we do believe that they should continue. So we would like to recognize the limits of any land acknowledgement and the harm that can be done by an inadequate or disrespectful land acknowledgement. And we would like to work together to find a respectful way to continue to center Indigenous voices. And I'd like to invite Charlie to offer us a land acknowledgement today.
Thank you, Commissioner Faith. I am Charlie Michelle Wesley. I am a tribal member of the Confederated Tribes of Grand Ronde. I am federally recognized there, but I could also be a tribal member of the Warm Springs Reservation and or the Siletz Reservation. So I am a multiple Northwest tribes. My people have resided here for ever since we can remember, right? And that's been a very, very long time. And I just, this is more like a land reminder coming from me versus an acknowledgement. That everywhere you live, love, work, raise your children, play, you have the privilege of being on this land that was once thriving with my people. And the key here is these land acknowledgements gave me hope that it's finally being recognized, that truth is the key here. Although just the beginning from the invasion of our beloved land, and the colonized nightmare that we experienced since 1492, and the ensuing corroding thread of racist assimilation and oppression that has been imposed on my people for over 500 years to this very day. Yet we resisted. We resisted the genocidal attempts and the dismantling of our way of life. And yet, you know, we persevered. We exist. And we're overcoming the horrors of colonialism. Yes, land acknowledgements are but a minute part of this, but it's a start, and it's often performative. But I must say, I never thought I would hear that admission in my lifetime, that this land is Indigenous land. And that alone, it warmed my heart. It's like, finally. But it must be followed up, because that is just the beginning. It must be followed up with accountability, reparation, and land back, and to lift us up and to celebrate our resilience. And for me as an Indigenous woman, that brings me absolutely no harm. I am grateful. Well, thank you. Hayumasi in my language, many thanks.
Thank you so much, Charlie. Thank you so much, Commissioner Charlie. Yeah, so appreciate that. I'd like to move on to our community agreements to give us a chance to read the agreements. Go right ahead. And then we will go to the next one in just a moment. Next slide, please. Our community agreements give us our bumpers, that give us our container for us to do this work in, and they are so very important. I would like to invite everyone to give me a thumbs up that you agree to these community agreements, please. Sophia. Yes, I see Connie's hand, Sophia's hand. Yes, thank you so much. Thank you, Jonas. Thank you all. Very good. All right, so our next slide is the timeline. And I invite Commissioner Lovisa in to walk us through the timeline. Beautiful.
Happily. Thank you so much, Dr. Moses. And thank you, Charlie, for for those words. Hi, everyone. My name is Lavisa Lloyd. I use she and her pronouns. I'm a member of the commission. And we're just going to go over roughly where we're at. All right, so the commission is currently in the fact-finding phase of work, which is expected to end this month. This phase of work includes hearing from key stakeholders, identifying barriers to accountability in Portland presently, and examining systems of accountability from other jurisdictions. It also includes increased community engagement work. Future phases of work will develop the parameters for the new police accountability system before the commission presents that to the City Council in 2023 for their consideration and approval.
Next slide, please.
Following today's meeting, the next 3 dates are reserved for the Subcommittee on Research. It will meet again September 19th and 22nd, and if it has not completed its work, it may also meet on September 26th. The full commission's next meeting is tentatively scheduled for September 29th. And sorry, I see the comment from the interpreter, and I will try to slow down a little.
Next slide, please. Thank you.
Thank you. This slide is the current project plan for the fact-finding phase of the Police Accountability Commission's work. It's not the agendas, and it is updated regularly. This slide is for members of the public to be able to understand how the commission gets from now through the end of the phase, which focuses on identifying areas of agreement among commission members as to barriers to police accountability in the current system, best practices from Portland and other jurisdictions, and suggestions to consider from experts, as well as taking public comment and meeting with key stakeholders. Today's meeting is in the blue box with the purple border on the upper right hand portion of the screen. Right, fact-finding phase documents. This slide shows the outcome documents for the fact-finding phase. The first 2 are being developed in the Subcommittee on Research, and the full commission will begin discussing them as soon as they are referred by the subcommittee to the full PAC. The third item is being developed directly at the full commission and is the focus of the second part of our meeting today.
Next slide, please.
Thank you. Today's meeting agenda has 2 primary purposes. The first is to hear from the United States Department of Justice, who the city has entered into a settlement agreement with in the case US DOJ versus City of Portland. Having heard from all other parties to the case, including the amici and the intervener, the PAC will now hear from the US Department of Justice. The second focus of today is on the draft areas of agreement on barriers to police accountability and best practices in Portland. A decision on this document is not expected today, but hopefully it will be near the stage of completion at the end of today's meeting. There will also be time for public comment during today's meeting, as well as the start of some of the transition tasks for the phases of work transition.
Thank you so much, Commissioner Lavisa. We'll now pass it over to the co-chairs of the Subcommittee on Community Engagement Events. That includes co-chair Tirsa and co-chair Christian to give a brief update on the progress of the subcommittee's work. Christian, Commissioner?
Hi, is Tirsa not here? I have been absent for 3 weeks. I just got back on Friday, so I don't know if I feel comfortable giving an update. As far as I know, there hasn't been much of an update. I did see that, I just been catching up on emails, and I did see that they made a little bit of progress in connecting with Don't Shoot Portland, I think. I can't quite remember the organization, but that's the only one that I think has made progress. I haven't seen any other people being reaching out or to any other COBs. I forget the name of the community-based art CBOs. Thank you to myself. Yeah, sorry for just getting back. That's why I don't feel comfortable. Yeah,
Welcome back. No,
cool.
anytime, not a problem. Welcome back.
Cool. Thank you. That's the best I can do. Sorry, everyone.
Absolutely, absolutely perfect. Thank you. We'll now pass it over to the co-chairs of the subcommittee on research. Co-chair Sophia and co-chair Angie, to give a brief update on the progress of the subcommittee's work. Who would like to step in? You might be having connection problems. Okay. Well, we can return to this area at a different time in our meeting later on this evening. So I am going to go ahead and move over to our briefing with the U.S. Department of Justice. I would like to invite in Deputy City Attorney Sarah Ames to give us the background before we have Mr. Hager, Jared Hager, and Mr. Jonas Geisler as our presenters from the DOJ. Attorney Ames.
Hi, my name is Sarah Ames. I use she, her pronouns, and I am the Deputy City Attorney that staffs the PAC. And I have met some of you virtually through these meetings before, not much recently, since you've just been churning along on the substantive work. I would like to introduce Jared and Jonas. I work very closely with them all the time since I was hired in last fall to work for the city attorney's office, in large part to help the city come into compliance with the settlement agreement with the US DOJ. And they are the opposing counsel in that role. They were the plaintiffs in the lawsuit that was settled by a long agreement on reforms that the city was going to undertake. They wear the hat of plaintiffs, but they also wear the hat as the monitors, working with the compliance officer and community liaison to kind of keep track and to monitor the city's progress and some of the data that comes out. And so as such, a lot of their work, there's a good chunk of it about the accountability system and some of the requirements of that accountability system and reforms that have been put in place. They have had an insight, a really unique perspective as monitors, in that they've had access to all parts of the accountability system from soup to nuts. They've been monitoring it against our agreement. And I think they have, you know, you've already heard from IA, you've heard from IPR. I shouldn't use acronyms, sorry, Dan. Internal Affairs and PPP, and you've heard from the Independent Police Review. You've heard from the police union. You've heard from Heidi Brown, who represents the city on a lot of personnel issues. So I think this is a unique perspective that will add to your understanding and their 10 years of experience monitoring the accountability system. So I'm really excited to have them here because they have a different perspective and can talk about the barriers and the practices that do work or don't work within the current system. I would also say you probably have seen Jared monitoring some of these meetings. And, I can't go without saying that, the Police Accountability Commission is the subject of a paragraph in the settlement agreement, which they're monitoring the compliance of. Paragraph 195B gives, once you all make your recommendations, the city has to pass them on, recommendations to code to institute the new accountability system that you guys are designing, the framework for that, and changes to the settlement agreement that are required by the changes you propose. Both of those go to the United States in the form of the Department of Justice for their review and approval prior to full implementation. So they have a vested interest in seeing that this accountability system, which they have helped reform and monitored for a decade, survives in even better form, in the new structure that you guys are designing. So they very much have an interest in the outcome of your work. And so that's why they're kind of watching the process to make sure y'all are still on track to deliver the product that they will then evaluate. I think that. So they're here tonight as kind of subject matter experts with a unique perspective from their years of monitoring, but they still are here also as monitors to see what the end result's going to be. And you'll see Jared on these calls, I think, for a while yet. So with that introduction, Jared Hager and Jonas Geisler.
Thank you, Sarah.
Thanks, Sarah. Hi, everyone. Thank you for having us. I'm going to give a few introductory remarks before I pass it to Jonas. I did just want to introduce myself. I am born and raised in Portland, Oregon, or Gresham. I like to say Portland because no one really admits they're from Gresham much. Went to Lewis and Clark College and have been with the Department of Justice since 2015. And I've done police reform work for the entire 7 years that I've been employed. I'm now on detail and normally out of the U.S. Attorney's Office for the District of Oregon in Portland, but I've been on detail to the Civil Rights Division in DC, still living in Park Rose. So I telework, but I am a trial attorney presently. Jonas, I believe, has been with the department for 20 years and has worked on numerous of these cases, but I'll let him give you his brief background. Jonas?
Thank you, Jared. And commissioners, thank you so much for having us this evening. I've met a few of you and I appreciate the opportunity to meet you virtually tonight. My brief introduction. It hasn't been quite 20 years, but close to 20 years I've been at Department of Justice. I've done disability cases and police cases. And this case was a really interesting confluence of both of those things, really the intersection of how police interact with people in a mental health crisis. But the case is a little bit broader. It's a Fourth Amendment case. It covers really all aspects of a constitutional violation for an excessive use of force. And I've had the pleasure of being on this case and with this team since the beginning of the case. So since we started internally considering it and got the internal correspondence from members of the community and from community groups that led us to start the investigation and then negotiate with the administration of the city. And I've seen some administrations come and go in the city and have had pleasure of working with PPV, but also with community groups. And I truly value the volunteer time that each of you put in. I have volunteered for other organizations. I know it is a heavy lift to try to fit this in among the many other things in your life. And without the least bit of pandering, I'll say, I know this is tough and I can only imagine the many things you have in your life. Thank you for putting in time on this one. Jared?
Thank you, Jonas. And then I echo the thanks that you guys are doing the elected officials' job. In essence, you are doing the people's job. And as a voter here in Portland, I especially appreciate the work you're doing in this capacity. Just a couple of words about what we do in the case. Sarah Ames gave you a brief overview. We are the monitor, and that means we assess the city's compliance with the provisions of a settlement agreement. And one section of that settlement agreement has to do with accountability, and we'll discuss that in a little more detail at the end of this 20-minute presentation. But we're also the plaintiff. So, we are lawyers for the United States. In that regard, we are trying to represent the public interest in constitutional policing, and we that is ultimately our client, justice. And as plaintiff, our role is to enforce any non-compliance with the settlement agreement, and that's what we did in 2020 and 2021, which led to the paragraph 195, which adopts this Accountability Commission's remedy as our own remedy, which I'll talk about a little bit more. In our role as monitor and plaintiff, we file reports with the court. We issue letters to the city with technical assistance or interim compliance assessments. What we're going to say tonight is largely replicated in those prior compliance reports and letters that we have delivered to the city and that are of the public record. The final thing we do is, again, we seek court intervention when it's necessary to get the city to honor its agreements under the settlement agreement and do what we think is appropriate and necessary to protect the constitutional rights of all Portlanders, all people who pass through Portland. We rely on a city-funded contractor, the compliance officer, community liaison, and they also file reports. We typically file a report assessing compliance once per year, and they are filing reports every quarter. Again, one section of that report will deal with the accountability system, and that might be of interest to you all. Two caveats about tonight. We are not authorized to opine on the strengths and weaknesses of other jurisdictions tonight. So we are sticking with our role as monitors and plaintiffs in this case. And so we are available to opine on Portland's system and where it has achieved or had difficulty achieving compliance with the accountability terms in the settlement agreement that governs here. There's lots of different approaches out there. I've sat in on these meetings. You guys are doing your homework. You know that common practice doesn't necessarily mean best practice. And so what we would encourage you to do is when you're thinking about analyzing those provisions, consider the implication of whatever parameter you're looking at, what implication that has on a timely, thorough, fair, and ultimately effective accountability system. And by effective accountability system, we mean one that will consistently hold officers accountable for violating their policy or their training. The second caveat is that we're not here to speculate about the future. I know that there was some interest in getting an answer from us about what potential changes you guys might propose and that the city might accept that would be difficult for us to approve, or I think the language you use might affect our eventual sign off. Now, all of your provisions are going to affect in some way our sign off because we're going to consider each one. But ultimately, it's what the city proposes to us. And the lens that we look at these changes are really going to be blank slate in some respect. What we can say is that the hallmarks of an effective accountability system are timely, thorough, and fair investigations that result in consistent discipline for violating policy. And that's sort of the rubric. Within that broad umbrella, there are a lot of ways to design an accountability system. The second thing I'll mention is that our adoption of this process into the court order that the settlement agreement is entered as, it is the result of a non-compliance notice that we issued in 2021 in relation to 2020 and the police response to protests. But these changes here to the accountability system are intended to remedy some of the compliance problems that we found. That is our intent. And so, for example, if the city wanted to say, we reject all of the Police Accountability Commission's proposals, and we want to keep the same thing, well, we would have a difficult conversation then. I mean, that is the type of thing we'll address with the city. That is out of your hands, so I think we basically, we don't want to tell you what to think, what to recommend. We are looking forward to your creative solutions. So on to the presentation. Jonas is going to start by giving you an overview of the settlement agreement terms related to accountability. You asked us what our current role is and approach to the accountability system, including investigation and discipline. And this is our approach. We assess compliance with these terms that exist in the settlement agreement that we think would create an effective accountability system if they were honored. So Jonas, can you run through the important terms of the accountability system?
Thank you, Jared. My apologies to Louise for speaking too quickly. And while I'd like to get through all these terms very quickly, I will try to speak slowly enough for an effective translation. If it is unuseful for me to speak about what is already in Section 8 of our settlement agreement in paragraph 169, commissioners, please let me know. Otherwise, I'll go ahead and proceed to talk about Section 8 and what we require of the city. First of all, intake of investigations with IA and IPR. The city had an organizational value taken from the public to preserve two methods of investigation, one being the internal affairs unit within the police bureau, and the other being independent police review at the auditor's office at the time, now independent. The settlement agreement memorializes keeping IA and IPR. IA would be the intake mechanism for internal complaints, and IPR would be the intake mechanism for external complaints. But that necessitates a two-step process. a complainant makes a statement to IPR, after their preliminary investigation, it goes to the police bureau, if assigned to the police bureau for full investigation, or it stays with IPR, and then there's a potential loss of time or information in the translation between the two agencies. We can talk about some of the steps we took on compliance findings for 2020 and before that remedied that. Part of the settlement agreement, Section 8, concerns timelines. We said investigation should be done within 180 days. This is for the benefit of both the accused and the person who's making a complaint. We believe that they are entitled to an expeditious resolution of their complaint, a feeling of procedural justice in the treatment, and an undue delay leads to a resentment in the system from both the community and the internal participants in the system. On-scene statements for deadly force. This was a provision that was modified after discussions with the district attorney for Multnomah County, and we specifically incorporated into the settlement agreement the Portland Police Bureau Directive 10-10-10. I encourage you to look that up if you have not already. I know you all have done a tremendous amount of work already, so I don't want to assume one way or the other. The requirements of 10-10-10 require the city to ask witness officers and involved officers if they will give a statement. The involved officer may refuse. A witness officer should give a statement unless they are incapacitated. Investigations, as I said, can go through either IA or IPR. They should be done within the time limit allowed, albeit there are certain means of delaying that time if necessary for protected leave status. Investigations are supposed to run concurrently. If there are criminal allegations and the administrative allegations, that means both of those investigations should be going on at the same time unless it is necessary for the criminal allegation investigation to delay the administrative investigation. That happens with some frequency when there's an overlapping allegation of criminal and administrative allegations. Appeals. Portland had, before we got here, the CRC, the Citizen Review Committee. We made slight changes to the CRC in terms of the number of members. Thank you for the addition of the acronyms. The CRC has a role in appeals. Either an officer or a complainant can appeal. There have been relatively few in the number of appeals that have occurred, and we have seen some in person, and we've seen some by Zoom, and we can talk about our findings with respect to those. Discipline process. Discipline should be fair and consistent, and we've memorialized in the settlement agreement that the city would develop a discipline guide that is essentially like a sentencing guide for anybody who's been familiar with the regular criminal convictions. It's a guide, how many days of leave you should have for a particular type of offense if one is sustained. And there are aggravating and mitigating circumstances in the guide. Aggravating, like they were a superior officer, they should have known better, or mitigating, like they were under undue stress from many, many hours on the job. Those are written out in the policy. Communication, there is a requirement that the city continue to communicate with complainants. This is done in the city through the IPR website. There's one of the specific questions that this commission asked us is that tracking system still working? As of our last compliance assessment report, I noted that there was difficulty, and something we can get to in discussion of compliance. There was difficulty in trying to click over from the IPR page to the tracking, but the direct link to the tracking page still worked. And then lastly, outside of Section 8, buried further in the agreement, is paragraph 169, and we have assessed that usually with Section 8. Paragraph 169 says essentially that you will hold people accountable for violations of policy. It is a catch-all provision, and it is a requirement that policies have to be effective. As our chief consultant, Chief Charlie Reynolds, says, a policy is not a policy if it is not enforced. So all policies need to be enforced fairly in order for the policy to be effective. Jared, would you like to discuss Section 11?
Yeah, thank you, Jonas. And after I talk about Section 11, Jonas will start in on the second question that you asked us. in relation to barriers to police accountability in the current system here and best practices from the current system here, what's worked, what's not worked. Jonas will talk about that, but I did want to talk about new section 11. New section 11 codifies 3 remedies that we believe are important or that arose from our accountability notice of noncompliance. The first is paragraph 192. It requires select investigations from independent police review. The first is related to training, and I think it's important for you all to understand that we had heard a persistent excuse that officers were trained in a way that was inconsistent with a policy requirement. Well, there's a separate policy requirement that you have to train people to their policy, and that deserves to be enforced as a policy violation, just like any force violation. And so we are requiring an investigation of lieutenants and above on who trained people to violate the policy or who trained people incorrectly. And related to that, there is a requirement that specialty units, report their trainings through the training division. And we know now that hasn't always happened. The second part of 192 is about reporting and review. After use of force, officers need to write a force report within 24 hours before the end of their shift. And it needs to be reviewed up the chain of command. I think the after action review has 72 hours. Well, that didn't always happen in 2020. And so we're requiring members of the incident command staff who excuse those reporting and review requirements during the 2020 protest to be held accountable for that policy violation. Again, it's not just violations of the force policy. Obviously, those are the most impactful, but these other types of policy requirements are equally important in our view, and they deserve to be enforced because they're essential to ensuring the constitutional limits are honored, and when they're not honored, they can be corrected. The final one is about management failures. There's a duty to correct misapprehensions of policy and to obtain sufficient information so that you can do that. And so that's the other investigation that we're requiring as a remedy. Paragraph 194 requires the Bureau to implement body-worn cameras for all officers. And what we found during the 2020 protest was that there was an insufficient availability of good evidence in order to assess officers' use of force. They were relying entirely on a written record. Sometimes that written record was not contemporaneously or near contemporaneously completed and reviewed. And that really is a problem for ensuring accountability in the middle run and long run. And so we believe body-worn cameras are a remedy that you all should be interested in, to the extent that it will allow for very quick available evidence that is going to be from an objective perspective. It won't be tainted by human bias. There are obviously other issues with video technology. It's not by any means a sufficient piece of evidence on its own. You've got to get all the other evidence, but it should inform your work. And finally, paragraph 195, you know about that. This is kind of interesting, from the Department of Justice perspective. We saw that 82% of Portlanders voted for this new accountability system. And so when we got to thinking about remedies for the 2020 violation, the Department of Justice has incorporated this remedy into our remedies. And so everything Jonas just said about what is required by Section 8, we know that might change, and you all should consider changing things that you think can be better. What you come up with and present to the city, and what the city approves will be presented to us, and that can really make for a progressive, innovative, and hopefully far more effective accountability system than we currently have. Now, all of that is going to be subject to the review and approval of the court. The court will apply a standard of, is this change fair, adequate, and reasonable? And that means a lot of stuff, but boiled down, I believe it means, does the accountability system ensure timely, thorough, and fair investigations that allow for consistent discipline against PPB officers who violate policy, not just the force policy, but other important policies like training, and reporting and reviewing. So with that, that is where we're at with the current system. And we know you want to know what's working and what's not working. So I will pass it back to Jonas to discuss our compliance assessment.
Thank you, Jared. And please interrupt me if it is unhelpful, but I'm offering, I want to only offer helpful information to you. I commend to your attention our fourth compliance assessment report. This was the one in which we found the city overall in compliance. Prior to the fourth compliance assessment report, we entered an agreement with the city wherein they would train together the internal affairs and the independent police review investigators so that all investigators would have the same standards on what to do and how to do it. And the city also agreed to have the investigators write the initial proposed findings, which was not the practice before then. That worked well. Having all investigators trained together worked well. Having the investigators write the proposed findings worked well. It corrected an error in time and accuracy wherein a responsible unit manager within the police bureau would have to review a file, try to learn the file, and then draft findings of their own based upon an investigation somebody else did. Now the responsible unit managers, they make the finding that goes up to the chief, but it is based upon the memo from the investigator that says this is the recommended finding. The responsible unit manager can disagree, and that's fine. Then they have to draft that into a memo. But if they agree, it becomes a more expeditious process. It's a short memo. I agree. Send it up the chain. That it helped with speed. It helped with knowledge of the file. It was a person closest to the investigation that helped the investigation accountability section cross the finish line with that compliance assessment report. And the 2021 compliance assessment report, our most recent one, the sixth one, I commend to your attention, section 8. And this would be the same sort of section for each of our compliance assessment reports. And I'll point out to you some recurrent themes of what has not worked well. Collateral misconduct and double jeopardy. Collateral misconduct to us, and you may have a different perception of it, is if an officer has an allegation against them and you're spending the very expensive time for an investigator and managers to review that allegation, when you see other things during the course of that investigation that are also a potential policy violation, not having to be nitpicky, but serious issues, one should identify collateral misconduct and initiate the separate accountability investigation on that. We have not necessarily seen that occur. Double jeopardy is an issue that we have reported on in a few of our compliance assessment reports. That is the perception that when an officer is cleared of an event, a day's event, all allegations for that day should be contained in that administrative investigation. And if there is a separate potential violation in that day or that event that is not included in the initial finding, then those are essentially out of bounds for a future investigation, because the officer will say, you've already investigated me for that day, and reinvestigating me for that same event would subject me to double jeopardy, just like any criminal defendant being tried twice for the same crime. I'm not saying this is an unreasonable position. I'm saying that identify all the issues within the day to avoid the issue of potential double jeopardy. Interference with administrative investigation interviews. There's already a provision in the collective bargaining agreement with the Portland Police Association that says don't interfere with interviews. We found that there were several instances of attorneys for the Police Association interfering with interviews. We understand from the city that it is the practice to permit a redirection at the end, but this particular citation was to more than just adding clarification at the end. This was changing the course of investigation interviews during the course of the interview. In Portland, that has been an issue. There will necessarily be a transition period to whatever accountability system the city ultimately proposes to DOJ. So though we mentioned that in this report, I don't think the transition is an issue right now. The CRC, the Citizen Review Committee, is the appellate body. We amended the settlement agreement years ago to give 90 days independently for the Citizen Review Committee appeal. That timeframe can be extended, and sometimes it needs to be extended by the attorneys for the appellant or the attorneys for the officer if the officer is going to participate. But we've observed in the past in prior compliance assessment reports, it is very difficult to have, and I'll speak to CRC generally, very difficult to have new evidence presented at an appellate level and have a finding from that appellate level stick. If you're the officer and you have an administrative charge against you, you go through the entire investigation, you have a proposed finding, the appellant goes before the Citizen Review Committee and presents a new piece of evidence. That should go back for administrative investigation and finding, and not be the basis for a recommendation from the Citizen Review Committee for a different finding. If an appellate body creates a new finding, that new finding may be subject to attack later in a grievance process. And grievance is where the attorney for the police union says, this is against our collective bargaining agreement. It's not fair under state law or our agreement. And so they may attack it. That's been a weakness in the appellate system. Though we've kept the appellate system in the agreement because that was the city value, this has been an unresolved weakness. On-scene public safety statements. There's been a strength in being able to ask involved officers for their public safety statement. We came to an agreement with the city wherein if there's no witnesses, there's no information that the city can obtain from other officers or other individuals, and there's a present danger. Imagine the situation where an officer shoots at somebody who's shooting at them, and you don't know where the rounds, the bullets are flying. If there's no other witnesses, the next supervisor on scene needs to know where the bullets went. In the policing context, that's called the public safety statement. They ask the officer, where did the bullets go? There's a set series of statements. There's a strength in preserving the ability to have a public safety statement from the involved officer. Witness officer statements, we've said in our compliance assessment report, was a mixed result. Witness officers, if they claim incapacitation, there should be an articulation of what that incapacitation was. And there should be in a discussion or memorialization, a writing somewhere from a supervisor that says, this is what we considered for the incapacitation. Otherwise, the witness officer should give a walkthrough of the incident. The conduct of IPR, independent police review investigations, has been a challenge. I believe if you look at our fourth compliance assessment report, there was a peak when there was a catch up to a backlog of investigations, and independent police review was able to do their own investigations. There was a difficulty in keeping pace with all the allegations that occurred from 2020. And there's a shadow effect from 2020 that affected our 2021 compliance assessment report. And so we said that there was a challenge in having meaningful IPR investigations. The Police Review Board. Portland has a police review board composed of members of the police bureau, some peers, some supervisors, and a director from the independent police review, and citizen volunteers from the Citizen Review Committee or other citizens who also volunteer for the police review board. If a finding in an administrative investigation, you may know this, forgive me if this is all rudimentary. If a finding goes to a police review board for review, it may be because there's disagreement among independent police review and the police bureau about the finding, or maybe because there's a potential sustained finding with discipline attached. The police review board process was the subject of a letter that the city asked us to write, and we wrote them in 2021. The police review board has been a challenge. Without getting into the deliberations of what is said at the police review boards, we said in our compliance assessment report that there was conflation, a mix-up of what is an aggravating and a mitigating circumstance, and there was justification of use of force based upon the actions of the crowd. That was in our police review board letter. That's not been a successful part of the accountability system in Portland in all respects. In some respects, there's a feeling of fairness to it, but it's lengthy to schedule the police review boards, and it is not necessarily they don't necessarily result in a recommendation based upon what the policy says, as we said in our police review board critique letter. For discipline, we said that there is a high point in that the city is establishing a corrective action guide. We had previously approved a discipline guide. The corrective action guide, the city negotiated with the police union. There's a potential for having more uniformity in the discipline imposed. But if the city does not investigate the collateral misconduct and all allegations of use of force, as we said in our compliance assessment report, then discipline is not necessarily imposed where it should be. And then I've already discussed the communication with the complainant. It is a high point in this city that complainants can get the status of their complaint. There was a specific question: do the complainants receive what discipline is imposed in the letter that it tells them what the outcome of the investigation was? No, the outcome of the investigation is sustained or not sustained or exonerated or unfounded, but it is the discipline imposed is not announced to the complainant. Jared?
Thank you, Jonas. That's, I think we're at 25, maybe a couple minutes over. We know it's my fault, Jonas, on the long trail. So we know that there was one, you all had some questions or maybe wanted some community discussion. That's essentially our overview. We know that the work you're doing is collecting a lot of input. We're excited to see what you come up with and what the city council might find agreeable. We hope they'll find work worthwhile.
Thank you so much, gentlemen. Truly appreciate that presentation. We're now going to go into discussion mode. And so we'll now take questions from the commissioners. Please keep your questions brief. Please allow me to facilitate this Q&A, and please ask questions that help the commission move towards identifying barriers to police accountability and best practices, which is the purpose of this phase of work. So I would like to call on Commissioner Jason, please.
Thanks. Hi, Jonas. Hi, Jared. Jonas, would you unpack a little bit of what you meant by challenges with the IPR? And then maybe comment on the things you found with the IPR that were exceptional, that really did work, versus just the things that didn't work. Thanks.
Yeah, Dr. Moses.
Go right ahead.
Thank you. Challenges specifically in this last compliance assessment report included access to records and the backlog of records at the records division within the police bureau. At the time, IPR had expressed to us that that created a difficulty in obtaining information to do independent investigations of their own. There was also a challenge in identifying officers, given the gaps in records in 2020. There was a difficulty identifying which officers were involved in incidents, and so therefore IPR closed some investigations for lack of identification of the involved member. Some of the successes, as Constantine Severe, the prior IPR director, set forth for us before, it's an allegation-driven system and people are open to come in. So the real success is the ease of access to entry by a civilian port, if you will, to have people come in and feel free to lodge a complaint. Thank you.
And I'll just add, you know, I know there's some of the investigators over there are high quality people. They take their job extremely seriously and they put a lot of time and effort and sweat into the work. They do have some systemic problems in terms of not being able to subpoena officers, right? They have to go through the police bureau in order to speak with officers. I don't think they can do a deadly force case. Is that right, Jonas? They go on scene, but they're not investigating those as well, which is a limitation.
Their practice has been not to independently investigate the deadly force cases. There's a great deal of expertise that goes to the deadly force cases, and state law invests the authority for deadly force cases in the coroner and the DA.
Thank you so much. Other questions? Commissioner Charlie.
Hello, thank you for that overview. Jeepers, I have 3 questions, so I don't know if there's time for all 3. They're kind of tied together. I guess the first one would be, you talked about undue stress as a oh my gosh, I'm trying to read my notes, sorry. When you talked about undue stress for possibly working long hours and so that could be like a barrier to being able to, what was that, make some kind of report. I can't remember the details, but I was wondering how often is that the case in your investigation, and how could that be addressed? I mean, that seems like a barrier, right? To getting the correct information reported.
May I, Dr. Moses?
Yes, absolutely.
So I was referring to the mitigating factors for the discipline guide. So I'm going to post into the chat the 2014 discipline guide. This is the one attached to the current discipline policy. This is not the corrective action guide, but this is the one that the Police Bureau has been applying through our last compliance assessment report. And it lists in the guide on pages 3 and 4 of the PDF file the mitigated, presumptive, and aggravated levels of discipline. So I think that would answer what those are. The how are they applied? It was misapplied in the police review boards, wherein if individuals had worked many, many hours or had been subject to violence in other days' events, because the crowd control went on for a great deal of time, that they would move to a different category in the discipline guide, a lower offense, if you will, rather than mitigating the level of discipline. So it's a table, and essentially they moved up and down on the categories instead of left and right on mitigation. For the other part, it was the officers on scene. Should they be able to talk, or should they be able to say, we are incapacitated? There's a real stress for individuals and officers. We're all human, right? Let's be empathetic with each other. So officers can claim, I am incapacitated. They could be physically incapacitated, it could be emotionally incapacitated, but there needs to be some articulation in the record as to what that was and why it was, and if it was legitimately exercised. And we spoke to that in our compliance assessment report. I hope that helps.
Somewhat, yeah. I was just wondering how often it's used.
Oh, very, very good. I'm sorry, I didn't answer that. I don't have a frequency with which it is used. There are fewer shooting events. It's a small numbers problem in any respect. If one looks at 6 to 8 events per year, terrible as those are, not minimizing them, But to try to say 50% or 2%, I think we looked at relatively few of those in which incapacitation was an issue.
Okay, may I ask one more question?
Yes, you may.
Commissioner Charlie, if I could just tack on first, that might be a better question for the police bureau. We sample the PRBs, we don't sit in all of them. And so we wouldn't have a perfect insight into how often discipline might be mitigated for a particular reason. That might be a better question for the city.
Okay, and maybe then this 10-10-10 question might be the same thing. Let me know if I can go ahead and ask. It says,
Yeah,
yes,
go ahead, Commissioner Charlie, go ahead and ask.
okay. In the 10-10-10, officers asked to make a statement and or the witness. And yet they can refuse. And so I'm just wondering, did you, in your sample then, did you find that to be frequent, to deny making a statement?
In
Go
each of
ahead.
the, I'm sorry, Dr.
Nope,
Moses.
right ahead.
In each of the officer involved shootings that we reviewed, the involved officer declined the voluntary statement on scene, and all were interviewed within the 48 hours as required by policy.
Okay,
Thank you so much. Commissioner
thank
Dan?
you.
Good evening, Mr. Hager, Mr. Geisler. I've engaged with you as a member of Portland Copwise, a member of the AMA Coalition. Tonight I'm here as a member of this commission. Dan Handelman, I use he, him pronouns. First of all, I'm going to correct little things that I heard that are not exactly accurate. And the last thing that just got said is that all officers got interviewed within 48 hours, except that the officer who was struck by a car had 48 days before they were interviewed. And that was very problematic, I thought. The word subpoena was used in terms of bringing officers in to get their testimony. And we have to be very careful with our language that we're talking about compelling them to testify as a condition of employment, because if we subpoena them, they'll just say, I plead the fifth, which is exactly the same reason they can say, I'm not going to do this interview on the scene, so that they don't incriminate themselves criminally. The law saying that the DA and the coroner are in charge of investigations, that's the criminal aspect of the shootings. Nothing in the state law prevents an oversight body like the one we're working on from conducting those investigations, or the IPR. What's protecting or preventing the IPR from doing that is the PPA contract right now, because it says that shall not be done. So I'm hoping that we can still make this work the way the charter was written. All right, so here's my actual question. Actually, yesterday morning, there was a case that went before City Council, which kind of continued a trend we're seeing where there seems to be a lot of internal cliques or, people who are in with each other inside the Bureau, and some people get special treatment and some people get special undue attention for investigation and stuff like that. Do you think that there's a value in us examining the idea that the new board would take all the cases, including ones that are currently considered internal, to get rid of those kinds of petty internal police on police disagreements that lead to partly why they don't trust the investigation system, I think. Do you see a value in that? And if so, can you express what you think about that? Thank you.
Go right ahead.
Thank you, Dr. Moses. Dan, you're absolutely right. Jared also corrected me in the chat. There was the one incident, and we did speak to that in the compliance assessment report. And we're currently in discussion with the city about whether or not incapacitation was appropriate and documented in that case. The city contends it was properly documented. The question you ask, I think assumes a lot of facts and evidence. So if it were asked in court, I'd say objection. I mean, I understand the perception of there are cliques, but I can't give validation to say a clique is going one way or the other. Is your question, should you investigate, or should you recommend a process for investigation of all complaints to avoid the appearance of impropriety. I see you shaking your head. Yes.
Sure. Yes, that's what I meant.
That I believe is your discretion, and I think goes to exactly what Jared said earlier. We wouldn't want to opine on what you should recommend. You should recommend what is best for the city and best for law enforcement in terms of keeping everything constitutional.
And I'll just add, though, that we are also very much approved to say that the hallmarks of an effective accountability system would avoid appearances of impropriety, would ensure the fair and the objective and the timely completion of investigation, the starting of investigation, and would lead to consistent discipline so that officers are treated fairly. Dan, and read into that what you want.
Thank you. May I ask a clarifying question? When you say the city, who is the city? Jonas, when you're talking with the city, who is that? If you don't mind clarifying that.
Oh, I'm sorry. Are you saying the record the city contends is properly documented? The city attorney's office. So
City attorneys. Okay,
yeah.
thank you so much.
Thank
Commissioner Lovisa, and then Commissioner Catherine.
Thank you so much, Mr. Hager and Mr. Geisler, for your presentation. Very helpful. I wanted to come back to the double jeopardy question and just ask, you mentioned officers complaining about being possibly called in for, I don't know if it's, called in for multiple interviews or multiple rounds of interviews about one day's activities and, additional misconduct that might have been identified, and then complaining about like sort of a double jeopardy thing. Did these officers offer any legal basis for this contention, or does the PPA offer like a legal basis for that?
I would invite the city attorney, particularly Deputy City Attorney Heidi Brown, who's their labor lawyer, to speak to the city's position on what double jeopardy is. Here's the situation. It's not just a day. I got called out to incident XX1, and in XX1, there were shots fired, and then there was a pursuit. Okay, this is one of the incidents from our compliance assessment report. I'm just making up the number. They go over all the shots fired stuff. They approve the actions of everybody involved in the shots fired, and they approve the actions of the supervisors for everything that they did. But they didn't assess the failure to have a debrief on the pursuit, which is in the pursuit policy. That sergeant could now say, you've already said I complied with the performance policy 315. So you cannot now go back and say I violated policy 315 for the pursuit after action, the pursuit debrief. Their argument is, I would be subject to double jeopardy because you've cleared me on 315, even though there's this outstanding aspect that also might be covered by 315. That's where we say, don't create the problem in the first place. Cover all the allegations right away.
And I'd just like to tack on that there's another implication of these arguments, and it might be worth checking with the union's lawyer too. I know Sergeant Smouts has spoken with you, but sometimes a whole accountability process can operate well, but then there is collateral litigation when a union challenges it on behalf of their member that it's an unfair thing, and that can end up getting settled by the city attorney's office. That can end up undercutting discipline in a way. It's something to think about, but we've encountered that in a number of our cases where stuff comes in and out of the accountability system fine, leaves the bureau fine, but then gets into collateral litigation that undercuts the consistency point.
Thank you so much. Commissioner Catherine.
Hello, I'm Catherine McDowell, and I use she, her pronouns, and I really appreciate your presentation tonight. I just had a question. I'm trying to understand that process a little bit better that we're going to be looking at when we get done with our work and we present? I know, you know, our goal is to get done with our work and present a proposal to City Council. And I guess I'm just wondering where in that process DOJ and the judge come in? Do they, in your opinion, do they come in after that we present it to the City Council and they make whatever changes they want to make and approve it? Or do we, is a better process for us to present a tentative draft to you and get feedback on it? I guess I'm just wondering if there's multiple audiences for our work, how do we ensure that we are getting feedback and responding to the needs and the interests of the different audiences involved? Thank you.
Thanks, Commissioner McDowell. It's a good question. I'm happy to answer it. How the paragraph 195B is written leaves the Department of Justice sort of not clearly defined, but I envision that you all will present your recommendations to City Council. They will have 60 days then to consider what they like, what they don't like, and put those in the form of amendments to the settlement agreement, Section 8. Maybe internal affairs goes away, maybe police review board provision, maybe it's supplemented with something different. At that time, when City Council is evaluating your recommendations to them, I expect we'll hear from the city attorney so that they can understand what might be acceptable to us, so that what the city agrees with will be agreeable to us. And then we'll take that after we reach agreement amongst the parties to the judge. The entire community will have an opportunity to opine or testify on whether they think the changes that the city and Department of Justice have agreed on, whether those are fair, adequate, and reasonable in terms of ensuring a timely, thorough, and fair accountability system, and also to address the concerns with accountability that were in the notice of noncompliance. Once the court approves those amendments, the City Council votes on codifying the ordinance changes. But the City Council will have to approve amendments to the agreement before we present them to the judge. So that's a little bit confusing too, whether they'll do the amendments, vote on those, and then vote on the code changes later, or whether they'll want to do that at the same time. I can understand there might be some uncertainty with the court's approval, but we'll be talking with the city, I think, quite frequently over that 60-day period of their assessment to get on the same page. Again, we do not want to prevent you from making changes or making recommendations. I think you should do whatever you think is best based on your research and your communications with community members.
Thank you so much. Sarah Ames put into the chat, the city's response to the DOJ compliance assessment offers some explanation of the double jeopardy issues under the law. And so that is helpful background information. I'm going to turn to you, Commissioner Charlie, and anyone else who has questions. Go right ahead.
Thank you, Dr. Moses. I was waiting to see if someone else had a question since I've asked so many. But I've always been interested in the training aspect of this. I think it was paragraph 169, section 11. You talked about training and if the interest in who trained an officer incorrectly, if it appears to be a training issue. And so if it's found out who trained the officer incorrectly, then what happens?
Go right ahead.
Thank you. I believe you're referring to paragraph 192 of the new section 11, which is.
Oh, was it 192?
169 said general, hold people accountable, but 192 was one of the specific additional remedies where we said independent police review should investigate, among other things, who trained and who didn't correct to use force incorrectly. That is resulting in an ongoing administrative investigation. And so we have not seen an outcome from that yet. But like any other administrative investigation, who would be held responsible? There would be an accused officer or officers, and that person would have the opportunity to present their side of the story. And it should be procedurally just internally and externally. Those people should feel that they're being treated fairly as well. And at the end, they would have a finding and the opportunity to appeal their finding to the Citizen Review Committee. Even officers can appeal sustained findings if they want to. I think that's happened once. Dan would know well. I think it's happened once in the past. But that one named person or persons would be the ones held accountable.
What about the trainer?
So the allegation should include, and we'll see in the end if it does,
Okay.
whomever trained them incorrectly, if they're responsible for the training. If I'm just delivering a message, perhaps I am not responsible, but if I drafted the lesson plan, perhaps I am. We'll have to see where the facts lead, and let the facts lead where they may, and not speculate as to what might happen.
Okay. All right. Thank you.
Thank you so much for that question, Commissioner Charlie. Commissioner Lavisa.
Thank you all so much for your patience and your stamina taking so many questions from us. I wanted to go back to intervention with interviews. You mentioned that you've seen several instances of PPA attorneys, while they're sitting in on interviews with officers, seeing them intervening with the interview. And I wondered if you could just like describe a little bit, is it interfering with the line of questioning? Like, I'm just curious kind of what types of activity are you seeing from the PPA attorneys in these compelled interviews? That seems improper.
Yeah, Dr. Moses.
Yes.
So it is not so pernicious that we see it in all interviews. I don't want to give the impression that this is happening for every single interview, Suriyatam. What we have seen in several instances is a question is asked, and then there is an interruption by an attorney, and the interruption says, the better question would be, or something to that effect. And that's what we spoke to in our compliance assessment report. And that has had the effect of distracting the interviewer from their line of questioning, distracting the line of questioning to a different line of questioning, and perhaps the original question not being answered.
Thank you so much. I would like us to move to the public comment and invite the public in to comment on the issues discussed in the briefing. We ask members of the public to keep their comments on the briefing or questions to the briefers to 2 minutes in length at most, and raise their hand in Zoom if they would like to speak. And I am not seeing any hands. So that then, yes, I think we can move on to a debrief, and we can let our distinguished speakers have their evening from now on. And we can say thank you so very, very much for being here this evening, for giving us such detailed and important information. And we deeply appreciate your expertise.
Thank you, Dr. Moses. Thank you, commissioners.
Thank you all, commissioners. Thank you so much.
Thank you.
So I would like to take a few minutes and ask our co-chairs if they want to debrief for a while, for like 5 or 6 minutes before we go to break.
Are you asking, should we take a break or should we debrief?
Debrief before we break.
Oh, yeah, let's debrief for 5 or 6 minutes. Let's do it.
All right.
All right, folks, remember how to do this from work. We're like old folks now. It's been 3 weeks since we've debriefed around barriers and best practices. But want to invite, and also for our newer commissioners, this is something that we've been doing when we've had speakers come and talk to us about barriers to police accountability in Portland. As a commission, we've had the opportunity to comment on things that seemed particularly salient or interesting. So I want to, and as well as comment on best practices that they identified. So I want to invite my colleagues. As Dr. Moses said, we have 5 or 6 minutes to chat about any barriers that were identified tonight.
And remember that when you're chiming in, and it's making it easier for the co-chairs to go back and to review this. And so your voice is very important to identify barriers as well as best practices. So Commissioner Lavisa.
Sure. Something that came up tonight that I don't know that I've really heard come up before is this collateral misconduct question. I don't think we've talked about this a lot before, but the idea about other serious issues that are identified during a misconduct investigation that are also worthy of being looked at, and is that being pursued aggressively enough? This double jeopardy question is very interesting. Thank you so much, Sarah Ames. I see that you put the city's response to the DOJ compliance assessment in the chat. Yeah, I also have, under best practices, I think they noted having the investigator make the findings, make the preliminary set of findings or the first set of findings was something that helped the city come into compliance, and it helped with speed, and it helped with knowledge of the file. So we may already have some version of this, but I just wanted to call that out as something I mentioned as a better practice.
Thank you, Commissioner Lavisa. Commissioner Dan.
Hi, thanks for that comment. I was just writing about that issue for the research subcommittee today, and I have concerns about because we're having community members who are supposed to be making the decisions about what the findings should be, and it's a kind of a double-edged sword whether it's okay for the investigators to give them their idea of what the findings should be. It is something we should discuss as we move forward. But I would like to put perhaps into the garden plot something that Commissioner McDowell raised, which is that after our tenure is done and we have turned in our proposal to the City Council, a lot of stuff is going to happen. It's going to go to the DOJ. It's going to go to the judge. It's going to come back to the city. They're going to put it into place. They're going to select the members. They're going to hire the staff, the chief staff person. They're going to hire the rest of the staff, and then it's going to get going. I think that with all of us investing all our time and energy into this, I wonder if we can put a little item for a future discussion about whether some of us should be kept on by the city as consultants during that. I don't mean paid. I just mean that as those things are happening, that we can help usher the new system in as the way that we envisioned it. So I just want to put a pin in that, so to speak. Thanks.
Thank you, Commissioner Dan. Commissioner Debbie.
I think we need to put on our things to remember as far as potential barriers is making sure that we somehow address that issue of the getting interfered, the interference during investigative, during the interviews. Because I think we want to make sure to prevent that in the new system if we can. The other thing I kind of wanted to and actually ask Commissioner Handelman about was Mr. Geisler talked, I think it was him, talked about how bringing in additional information during the appeal process. And my understanding, based on observing the CRC, is that if new material comes forward at the appeal hearing, Then the rule is now it goes back for additional investigation. So they don't just get to take new information in and make a decision. They get to say, oh my goodness, this new information seems important. IA or IPR, you need to follow up on that and then bring the case back to us. And then we will make our recommendation. And I see Commissioner Handelman's shaking his head yes. So I'm glad. I would like, I think it'd be good if we had an appeal process, and I don't want to undermine that possibility by making, casting doubt on the one that we have right now. Okay, thank you.
Thank you, Commissioner Debbie, Commissioner Lavisa, and then Commissioner Monica.
Yeah, I'll be brief. I just wanted to say I agree with Commissioner Debbie about the PPA attorneys intervening or interfering somewhat with lines of questioning, and also that I noticed they mentioned that really relatively few. I think we've heard this or we talked about it a couple times, but just that there are relatively few cases that go to CRC for appeal, and yeah, I agree with Debbie that I don't want to destroy the appeal process, but that it is interesting. We didn't really end up asking them sort of what their opinions were about why not a lot of cases make it to CRC. It's that might be kind of requiring them to speculate, but I think based on the knowledge that we have now and the presentations we've had, we probably have some guesses about why. Or if anybody wants to speak to that really quickly in the time we have, I'd be happy to hear.
Thank you, Commissioner Lavisa. Commissioner Monica. Cannot hear you. You're on mute.
Thank you. My impressions from this presentation were that it's really, it seems like it's extremely important that investigations are super thorough, complete before they move on to the next step. And it would behoove us to find out what exactly makes a thorough, complete investigation before it moves on to next steps, so as not to end up with mishaps afterwards, or allegations of, I don't know, allegations being cleared for, missing details in investigations that then later come up. I thought that was pretty key.
Thank you, Commissioner Monica. So I'm going to ask Commissioner Catherine to hang for just a moment. And I'm going to give the floor to Commissioner Angie to give us an update on the other subcommittee. Yes.
Thank you, Dr. Moses. Can you hear me? I'm sorry, it might get really noisy. I'm in an airport right now. I just wanted to update everybody on the research subcommittee in that I will be sending out some emails in the next couple of days to get some clarification before, so sorry. You won't be able to hear me if I talk. I'm sorry, but I'll be sending out some emails to get some clarification from people on the commission, on the subcommittee, and I have to drop off this call because I'm going to be busy. So anyway, thank you very much, and thanks everybody for your work on the subcommittee. Hopefully, we are trying to do as much work behind the scenes to make our subcommittee meetings run a little bit more smoothly and quicker, and hopefully we can get the work done in the next couple of meetings and be done with that. Thank you very much, everybody, for your work, and I'll talk to you on Monday, probably. Bye.
Thank you so much, Commissioner Angie. Commissioner Sophia, do you have anything to follow up? Do you want to add anything? Nothing? Okay, very good. Thank you. Thank you. Commissioner Catherine.
Thank you, and safe travels to Angie. Appreciate her efforts in calling in such a hectic moment. I just want to say, I felt like it was pretty important. The DOJ lawyers a couple of times really put out their standard for what they were looking for in a system, and I just took the note that does the proposed system provide timely, thorough, and fair investigations and lead to consistent discipline. So it just seems to me that knowing that the DOJ and the court and all of that will be monitoring or reviewing our results, it just may be useful for us to ask ourselves that question as we come to, as we're producing our final proposal, understanding that after the city council, we also have a DOJ hurdle to clear, and just really ask ourselves, do we meet that standard, since that's the standard they articulated today? Thank you.
Thank you so much, Catherine. Commissioner Catherine. Commissioner Levis, I'm going to go to Commissioner Christian, and I'm going to ask that Christian be our last commissioner at this time, and then we're going to go to break.
We might have time for Livy, so mine's very quick. I just wanted to agree with Commissioner Catherine about the word consistent really stuck out to me, both in the context that she gave and also in the context that it goes well along with putting trust, having a trustworthy system. If we have consistent results, then the community may trust us more. That was another reason why that stuck out to me. That was all. Thank you.
Beautiful. Thank you. All right, let's take 5. Let's come back at 8:07. And thank you so much for this wonderful conversation. See you back in a bit. Beautiful. Welcome in. Welcome back, everyone. We are now going to move into a discussion of the draft areas of agreement on barriers to police accountability and best practices in Portland. This document is probably not going to be voted on today, but will be worked through and adapted for future approval. Next slide, please. This is an open discussion, and we ask you to follow our normal discussion rules. Please be brief each time you speak, even though you can speak multiple times. Please be facilitated, and remember that the commission uses a weighted stack in our discussions. Finally, please be forward-looking in your comments. Would the co-chairs like to frame the discussion and then get us started?
Sure. Hi, everybody. Lavisa Lloyd, you know me, co-chair of the commission. So once again, thanks everybody once again for your stamina. I know this is a really long meeting, so thank you everyone so much. We're going to take a few minutes here to look at this document before we move on to the next parts of the agenda. We co-chairs have been looking at the document, integrating comments, and just kind of doing our best to, clarify and condense things down. And in a couple of places, we've added some new language that we're hoping kind of clarifies a couple of things, sort of moving a couple of things around just to try to make things a little clearer. So I thought probably the best use of our time today, since we don't have a ton of time, is to take a look at these new sections of language, and then to go ahead and move on and take a look at the best practices language, so that we can put eyes on all of the language in the document at least once, because I don't think we've gotten a chance to do that yet. So we are gonna start, if we can start, I think section 9 is kind of the first place where we have some new language. Thank you so much to our staff for your wizardry. All right, so section 9, the standard of review. So this is something that had come up a few times, the standard of review. The standard of review is too high in both the initial decision-making processes and on appeal. And just for clarification. I think this is under the policy section, current laws and policies, but we're not married to that. It can move someplace else, but this just seemed like the most logical place to put it for now. All right. Section 9, the standard of review is too high in both the initial decision-making processes and on appeal. Findings. The initial determination of facts, findings, and assessment for discipline are based on a reasonable person standard, not a preponderance of evidence standard, which creates an unduly high burden for corrective action. Appeal. The Police Review Board has to look at the decision made by the commanding officer, not a preponderance of evidence standard. We welcome fact-checking. We welcome any thoughts or comments on the content here for how it's been organized.
Commissioner Dan, thank you.
Yes, thank you. I think I might have typed this part into the chat last time, and maybe I did something confusing, but the standard review is too deferential, it should say, instead of high. And then only in the appeal process, not in both the initial decision making, because the initial decision making is done on a preponderance of the evidence. So I don't know how those got conflated. If it's something I did wrong, I apologize. And the Police Review Board is not involved in the appeal. That's the Citizen Review Committee. So basically, that the explanation section should say, on appeal, the Citizen Review Committee has to use a reasonable person standard to consider commanding officer's decision rather than a preponderance of evidence standard. And that's what is currently how it works.
Okay, so sorry, Dan, did you say your suggestion is that the standard of review should be changed from too high to too deferential, and specifically only in the appeal process?
Yes, that's correct, because in the lower levels, it's preponderance of the evidence.
Okay, so let's see. So under findings, the initial determination of facts, findings, and assessment for discipline are based on, so they are based on a preponderance of the evidence. Is that what you're saying? And not on a reasonable person standard at that point?
Sorry, I didn't get a chance to snack during the break because I'm eating right now. But
That's fine.
That is the initial findings phase. We can just pull that whole thing out. To appeal, the Citizen Review Committee has to look at the decision made by the commanding officer using a reasonable person standard, not a preponderance of evidence standard. And
okay.
Putting reasonable person in quotes is a good idea, because that's what, And I'll let Commissioner Iona weigh in if there's something I did wrong there, because we've been following this for a very long time.
Thank you, Dan.
All right. Any
Other
other
comments?
conversation on this? I'm sorry to.
Oh,
interrupt.
no, sure. Yeah. Any other comments? Any other facts to find on this?
I would like to do a little thumbs upsies for just the bolded number 9. So if we are changing it to the standard of review is too deferential in the appeal process. Does that work? Not the initial decision, the initial process. Yeah. So, yeah.
All right, so as written now, it would say the standard of review is too deferential. Can we say to police? To maybe clarify who it's too deferential to? The standard of review is too deferential to police in the appeal process. Do folks feel good about that as a statement of a barrier in the current process? And if you like it, can you give a thumbs up or maybe a hand signal of some kind?
I see jazz hands.
Thank you. Thank you. All right, I'm seeing some general support. Thank you so much. Okay. Thank you. Thank you, Jay. I see your thumbs. All right, let's go ahead on to, I think, the next chunk of new language, which I think is under 15 and 16. All right. Thanks. This is under the section, the barrier is inadequate resources for community oversight. And this was a suggestion to change from civilian oversight to community oversight. 15, community volunteers who participate in the current system often feel their involvement is meaningless because it lacks real authority. Final decision making. The final decision-making power is vested in entities other than the Citizen Review Committee, which makes members of that committee often feel that their input is not heard when their recommendations are not taken. Community volunteers on the Police Review Board are outnumbered by police. Lack of response and implementation. Policy recommendations from community entities often do not receive a response from decision makers in a timely fashion. Even when they are responded to, community input is not regularly taken. Public input and testimony from the Citizen Review Committee indicates that volunteers often feel like their work is meaningless because their recommendations are often ignored by the city and the police. Do folks have fact-checking, site-checking, general feelings about the content of this?
Commissioner Faith.
I think my only caution around this is for stating that this is a barrier that we want to fix, that we're making sure that we are not just we've heard directly from CRC, they do really value their work and they do really value being on the committee. So I just want to make sure that the way that we're stating this isn't overstated, that we're identifying that CRC is meaningless. And maybe I'm just being too cautious.
Thank you for that feedback, Faith. I think that's great feedback.
Commissioner Dan.
Thank you, Co-Chair Aiken. I think I see the word often in 3 of the 4 sentences here. So I think that's pretty much covered, but we can soften it more. I think right now I feel comfortable with most of it. The thing where I'm stuck is making a parallel comment about the Police Review Board to the CRC. So it'll say community volunteers on the Police Review Board, comma, who also only make recommendations are outnumbered by police. And that way it's clear that they're not the final decision makers either.
Thank you for that. I think, oh, sorry, Dan, do you have something else? No, not at this moment. Okay. I wanted to go back to Faith's comment. I think maybe the phrasing of the barrier is a bit strong. Community volunteers who participate in the current system often feel their involvement is meaningless because it lacks real authority. I would say maybe another way of putting it might be community volunteers who participate in the current system often feel their contributions are not valued sufficiently, or something along those lines, or that their work is ineffectual. Maybe something like that.
Thank you, Commissioner Lavisa. Commissioner Monica.
I was gonna say if we just take the word meaningless out, we could just say community volunteers who participate in the current system often feel their work is ineffectual because it lacks real authority, and just take meaningless out.
Thank you for that suggestion. Commissioner Debbie.
Okay, here's another one. How about they could say often feel that their work would be more meaningful if they had more authority?
To flip it around.
Yeah, that kind of, yes, shifts it.
Thank you, Commissioner Debbie. I think this is helpful that the co-chairs have the meaning. We don't have to wordsmith all of it, but yeah, I think this is very helpful.
Thank you. How do folks feel about this as a barrier that community volunteers in the current system have the sense that their work is ineffectual or ineffective because it lacks real authority? And if you feel like you can support this as a statement, please give a thumbs up or a jazz hands, something along those lines. Okay, thank you. Thank you very much. That's really helpful. Okay, I think let's go on to the next chunk.
Commissioner Lavisa, I just wanted to note in the Q&A, this goes back to our previous conversation. Rochelle Silver says the CRC has trouble with their standard of review and would like that changed. And so that is a Q&A comment. Just letting you know and put that into the record.
Thank you so much for that comment. Staff will add that.
Thank you. Okay. Onward and upward.
Thank you. All right, I think we'll head to the next chunk of new language, which I think is 16 under the current numbering system. All right, thank you so much. Okay, so this is sort of based on a conversation we had last time. We had a conversation about a quote that came from Mayor Wheeler that was about the city council and the city council not feeling it had sufficient capacity to do justice to these cases that come before it occasionally. And so we talked a bit about, do we even want this quote in here? Is it implying some things that we don't want to imply? But also noting that, like, maybe there is some good information there. So maybe we can find a way to incorporate some of the information without necessarily quoting Ted Wheeler word for word. So that's the thought behind this. All right. So, and then are we under the same section? Sorry, can we just scroll back up to see which section we're under? This is under, yeah, this is under inadequate resources for community oversight. Thanks. 16. Some cases involve city council decision making, and the city council is not the best entity for community involvement in decision making. Focus and priority. The city council addresses every part of the governance of the city of Portland. Its breadth has numerous advantages, including accountability to the public, but it does not focus on these issues, nor can it prioritize its work in this field, making it an appropriate venue for the direct adjudication of some misconduct allegations and decisions on corrective action. Expertise. The city council does not have the specialized knowledge necessary to make detailed decisions on administrative accountability cases. And then we have the quote, which we can cut. We can keep the language, we can cut the language. Tell us your thoughts on the language. Tell us your thoughts on the facts of this.
Thank you, Commissioner Lavisa. Commissioner Dan.
Hi, yeah, my problem isn't with the quote, because that's a real quote. My problem is with this being listed as a barrier with no conditions attached to it. The city council has been involved in the appeals of misconduct since 1980 in this city. And there was, I think there's a value in the elected officials of this city being forced to listen to the details of how these cases play out on the streets, and then how they go through the system, and then what the end result is. to help make those decisions. You know, I've been saying for some time now that if something happens where the review board itself that we're working on has the authority to discipline officers taken away from it, that's got to be, you know, we have to find a substitute for that. And it may be city council, and it may be, and I guess I'm, you know, throwing my hand down now on something I've been thinking about for a while, but it could be city council, it could be the Bureau of Human Resources, which has purview over all the employees of the city. But I don't want to dismiss that the city council having a role in these cases. I think there may be more conditional language that we can put into the barrier, you know, the heading, instead of is not the best entity, say may not be the best entity or something along those lines.
Thank you, Commissioner Dan. Commissioner Faith.
I just want, thank you, Commissioner Dan. I'm curious around, like, what do you think more narrowed in is the barrier with city council? Like the lack of time that they're able to commit to understanding the cases, like the political component. I wonder if there's a way that we could isolate specifically what we're trying to say here, and if you had a thought on that.
Well, I think that the barriers that are presented here are reasonable, but I just don't think that overrides the structural institutional question of whether or not we should be putting our elected officials in a position of making a decision that's important for the community, and to help keep our police accountable when nobody else is doing it. You know, we don't know whether this charter change is going to go through, not our charter change, but the charter change that is being proposed now will go through and change whether these individual city council members will have to run bureaus anymore. Certainly that could free up a lot of their time. And we've run into a couple of times at city council where it was either stated explicitly by a city council member or implied that they didn't read the case file that they were supposed to read before they had the hearing. So that, you know, that definitely has been a barrier, the way the system works now. But from a structural, as I'm saying, I'm going to say one more time, from a structural and institutional standpoint, it may not be a bad thing to have city council involved in these cases.
Thank you, Commissioner Dan. Commissioner Debbie, and then Commissioner Lavisa.
So I just want to agree with Commissioner Handelman in the sense that I feel like there is real value in having the city council involved in these cases. I mean, I'm sure Commissioner Handelman has done the analysis. It doesn't happen very often, you know, not even once a year, I'd say. And so it's not taking up a ton of their time. And when it comes, it does. But I think for them to put themselves in the shoes of the CRC members and in today's you know, era, that and see firsthand how these cases, what's involved in them and what's the investigation look like and everything, is very instructive and good for them to know about. Plus, I don't know if this is entirely parallel, but you know, they act as a quasi-judicial body in land use cases. So it's not like this is something that's just totally unheard of in their list of responsibilities. So it seems like that's sort of a similar thing that they do. And I think when they do that, there's a whole lot of reading they have to do and they have to be prepared. So I don't know. I have found value in seeing them do these every now and then.
Thank you so much, Commissioner Debbie. Commissioner Lavisa.
So it sounds like we actually have some disagreement about sort of fundamentally, like, is this a barrier, or more specifically, what is the barrier, if there is a barrier here that we want to include in this document? And you know, obviously we will not we definitely will not be able to include every single barrier in the current system in our document. We just don't have the organizational capacity to do that. And the document would be 1 million pages long probably. So I think maybe could we sort of do kind of a soft poll for whether let me ask, do people agree that the statement, let me think. Okay, so first, can we change, and the city council is not the best entity to, and the city council may not be the best entity? Okay, as written, some cases involve city council decision making, and the city council may not be the best entity for community involvement in decision making. Do folks agree that that is a barrier, the way that it's written right now? Is there?
Commissioner Monica, you're on mute.
Thank you. I'm getting the impression that this is here because this was Mayor Wheeler's opinion, and it was a very strongly stated opinion, which I found I mean I found it surprising. And it only has happened 4 times, and those 4 times since I just saw what, since 2007. It seems like the city council should be able to provide the attention that those cases need, because those cases would be important in the fact that they went all the way to city council. So I'm torn, honestly, because Mayor Wheeler was very strongly thought that this was something that should not be in the hands of city council. And I believe some of the other city councilors also said the same thing. So I'm confused by this one. That's what I would just want to say.
Thank you so much, Monica. Yeah. All right. Yeah, I'm not seeing a super strong agreement on this as a barrier, so I propose that we cut this language. How do folks feel about that? If you agree with cutting the language wholly.
Like, sorry, I just want to clarify, like cutting the whole section.
Yeah, cutting the language and the quote, just cutting it. How do folks feel about that?
Yes, hands.
Commissioner Kiana, I don't think it should be cut, maybe just reworded, because there is a problem in the accountability process with city council handling a responsibility that is theirs. And it kind of seems like a barrier to accountability on Ted Wheeler's part. But so there is a problem and a barrier there. Just kind of, it does need to be worked on it, but it seems like a lot of people touched on kind of what the problem is too. So, but I don't think it's like a bad statement. Yeah, just changed around, because I don't know if he was saying that it's a problem because they're understaffed, or it's a problem from the public because the city council isn't being as prepared as they should be. But there is a problem there.
Thank you.
Thank you, Kiana.
Commissioner Faith. And we're going to need to move into
Okay,
the
sorry.
next section here pretty quickly. So
thanks for that, Commissioner Kiana. I'm curious if there is a way that co-chairs can work on rewording this. What is coming to my mind is that, like, perhaps the way that it's been, city council has participated in the accountability process so far has not been particularly meaningful. And I think that is general enough to not put us in a position that we are nixing participation from city council in the future. But I guess kind of my thought and recommendation is that based on this feedback, co-chairs can take a crack at rewording this.
thank you, Commissioner Faith. Commissioner Sophia.
I'm not sure exactly where when and this language came in, but my thought was it surrounded that the mayor had the final say, and that they were not allowed to be involved in the process until the very, very end. After the police chief, after everyone gets done, and they weren't allowed to know anything because they're supposed to have this unbiased so-called decision making, and having that be the case, they really didn't know much about the case and how to most appropriately make that decision. That was my thought. I'm not sure where this came from, but I do remember that being a part of it. So that's all I wanted to add. Thank you.
Thank you so much, Commissioner Sophia. Commissioner Dan, like 10 seconds, and we have to move on to the best practices part.
Fair enough. Okay, a few years ago, the rest of City Council outvoted the mayor to find a sustained finding, and that's why he doesn't like this process. So take that for what you will. So I don't think meaningful is the right word. I think it's more about, concentrated involvement or something like that. Thank you.
So we'll need to table this, and the co-chairs will need to come up with additional verbiage. And it is now time for us to go into best practices. Pretty please.
Okay. Good evening, y'all. We have not had the opportunity to talk about best practices. So here we go. You will notice that the formatting of this section is not the same as the formatting above, and that is because there simply was not as much content. So I'd like to maybe I'll go through the first couple and then take a pause. So transparency. There are elements of the current system that prioritize transparency. First, the current system holds public meetings. Meetings of the CRC are open to the public and offer time for public comment. Additionally, CRC appeal hearings are done in public and allow for community input. The current system publishes data and regular reports, even if imperfect. Accessibility and equity. The current system prioritizes access and equity through language access, as investigators speak and can complete intake in multiple languages. As one of the multiple points of entry, employees of PPB may make complaints outside their chain of command. And finally, the current system has its own outreach coordinator. Since this is not quite as clear-cut as the sections above, I guess I'm asking two questions. One, nope, just one question. Do you agree that what has been highlighted are areas of best practice that we've heard? Let's start there.
I see some jazz hands and nodding. Questions at all? Comments? Commissioner Dan?
This is the same comment they made about the research subcommittee document. I would think it would be so much more readable if each separate sentence that's a different thought gets broken into a different line, because right now it's just like this big blob, but each one of these is an individual thought. So I'd really like to see those broken out into separate lines. Thank you.
Great. Thanks, Dan.
Any other comments on this? I know it's a first read. Next section.
Okay. Civilian staff involvement. The current system has multiple avenues for frontline staff to be involved in the investigative process. For example, IPR staff can go directly to the scene of officer deadly force incidents. Additionally, civilian staff can complete intake and intake investigations. Staff can do mostly independent investigations and have nominal subpoena power for documents and people. I'm going to do 2 sections at a time. Qualifications of investigators. The current system has experienced investigators. PPBIA investigators collaborate, team up, advise, consult, share information, knowledge, and experience about how to conduct investigations. All PPBIA investigators have prior investigative experience, including experience with sex abuse, homicides, criminal, personnel, and administrative investigations.
Thoughts about these 2 sections of best practices? Commissioner Catherine?
I just wondered why we're only talking about PPA-IA investigators in the qualifications, because I do feel like we have heard from multiple sources that the IPR investigators are highly qualified and meet all of these criteria. We just heard that tonight from DOJ folks. Thank you.
Thanks, Catherine.
Thank you for that observation. Yep.
Okay, general sentiments are these best practices that we heard. We feel good about this. Thumbsies, spirit fingers.
Yep.
Okay.
Thumbs up. Yep.
Great. Cruising. Okay, the next 2, review and rigor. The current system offers multiple points of review and opportunity for appeals. At any point, investigations can be sent back to an investigator for further work. There is an appeals system in place for both employee, the Louderman hearing, and for community members, the CRC appeal process. There is rigor in the investigative process in the current system. IA always finishes the investigation, even if the employee accused of misconduct resigns while the investigation is ongoing. Further, the separation of the investigation phase and corrective action / discipline phase can remediate potential conflicts of interest in investigation. Outcomes. Beyond discipline or corrective action for the subject officer, the current system has capacity for other outcomes. The current system can make policy recommendations. And I'm going to go for this 3rd one, mediation. An additional outcome of the current system has an option for mediation.
Thank you, Commissioner Dan.
So there's a lot to digest here. Okay, so I'm going to start at the top and move down. The first point about the appeals, the employees and community members can both appeal to the CRC. We heard that from the DOJ, and I put again in the chat the document where Fort and Copwatch tracked those. I think that, okay, that's one way to do it. Okay, sure, that works. Outcomes, it says the current system has capacity for other outcomes. I can probably name them, but I think which should be good for us to name 1 or 2 examples there. And I can either supply those to the chairs or maybe we have them in our notes somewhere, but I can't think of them right now. It's getting late. And mediation, I would not call mediation an outcome. I would say avenue current system is an option for mediation. So that comes at the point where the person has filed the appeal, not the appeal, the complaint, but before a full investigation happens, they get to talk to the officer one-on-one. So that's not an outcome, that's it's just a procedure. So, or, an avenue for them to opt into.
Thank you, Commissioner Dan. So mediation can happen before an investigation? Is that what you're saying?
Yes, it has to happen before an investigation, because if the case gets investigated, they can't be mediated anymore. And well, that may be something we want to discuss later down the line, but that's the way the system currently works.
Thank you. Commissioner Faith or Commissioner Sophia.
My question is, if mediation, can they come to an agreement, or is it a way for them to have an agreement in mediation to avoid the investigation? And if so, I guess that's some type of outcome. I'm just asking the question.
Commissioner Dan.
Well, so if the mediation fails, then it can go. I think it can go to an investigation. But the idea is that it's an alternative to investigation. So the officer, there's an incentive for the officer to go in there and talk to the community member instead of getting the investigation. And the outcome of that, in my opinion, having gone through this a few times myself, is that sometimes it's more meaningful to the officer to have the person say, you did this to me and this is how it made me feel, than it is for them to have their supervisor say, oh, you made a minor violation and here's your letter of reprimand. So it can lead to a meaningful outcome, but the outcome is not the mediation itself. The outcome is the understanding that comes between the community member and the officer. I hope that makes sense.
Thank you so much, Commissioner Dan. Commissioner Sophia.
I just wanted to say, in mediation, is the community member allowed to ask for something, some type of relief, or not? Or is it just, I get to see you face to face, or is there an agreement that comes out of that with relief for the community member? I'm asking these questions because I just want to know what comes out of that. Is it just seeing somebody eyeball to eyeball, or is there an actual agreement that has to, like, is a contractual agreement that these folks have to abide by, or else it will go into a full investigation? I just wanted to make sure.
Commissioner Dan.
So that's a good question. I think that I can see that being useful, but the idea is that this is very informal, so that the parties will presumably walk away saying, okay, I heard what you had to say and I understand it now. So I have, because it's confidential, I can't say exactly what happened in my mediations, but in both cases that I did, the officers, the mediators didn't seem to understand my point of view, but the officers did. So, we walked away agreeing to disagree, even though the mediators wanted us to agree on something. So I think that there's still a value to it, even when you can't agree on something, that there was active listening going on, where you have to repeat back what you heard and walk away hearing what the other party had to say. And that's what mediation is. It's a procedural justice. It's something we've been talking about in the commission, about maybe finding something that's not necessarily punitive as a way to try to transform our bureau. So that's why it's been one of the things we've pushed for. My group has been pushing for since 1992, when we started working on this issue. And it's not used very often, unfortunately. It's only used about 8 times a year right now. But there's a lot of systems that rely on it a lot more heavily than Portland. So it is I think it's a good aspect, and it's a positive thing for this system.
Thank you, Commissioner Dan. Commissioner Faith, we need to wrap up this. So I'm going to ask you to do that.
Yep. Can we, staff, would you mind just scrolling up real quick? Can we do a quick thanks y'all for the feedback, particularly around mediation? That was clarifying for me, and I can work on that. Generally, are these 3 themes of best practices ones that we can agree on? Spirit
it's
fingers or thumbs up
connecting.
for y'all if this is an area where you can agree.
Yep, I'm seeing
Okay.
thumbs, yes, yes.
Cool. Thank you all so much.
Beautiful, beautiful work. Thank you, everyone. Time check, we have 9 minutes left. We're gonna go to public comment on this particular part. And so I am going to ask for public comment. Public comment, you have 2 minutes in length, and I see that we have an attendee with Darian Jones with their hand raised. And so welcome in, Darian. Please give us your comment or question. Welcome in.
There seems to be an error. I don't have a question. Sorry.
No. Okay. Okay. Very good. Anyone else? All right. Thank you so much. So then next steps. Co-chairs, member curiosities.
Yes. I don't even need to give an introduction because Debbie has her hand up. So
Very good.
I know we're in a hurry. So I just wanted to follow up from what I mentioned last week about the some of the information in the internal update that we get by email, I think would be interesting to members of the public who attend this. I know we don't have a big crowd, but there are a few people who show up. And just examples from this one we got today, like the fact that we have a community engagement staff person might be interesting. The fact that the quarterly reports that we presented to City Council next week, is that right? Would also be interesting. And any announcements about upcoming meetings, I think might also be of interest to the members of the public in attendance. Thank you very much.
Thank you, Commissioner Debbie. Commissioner Dan.
Yes, I agree. I also saw that part of the email today announcing that Wednesday the presentation is going to happen. I think 2 or 3 of our co-chairs will be presenting that. The City Council agenda says it's 10:35 a.m. I generally don't comment on that as a member of the public, since I'm a member of the commission. Somebody else from CopWatch may do that. Regardless, part of this report is that we wrote our letter to City Council about the quorum question, and I don't know if that's going to be emphasized, but I hope that we keep putting that in front of the City Council in hopes that maybe they will get back to us with an answer about our quorum question at some point. Thank you.
Thank you so much. Anyone else? For member curiosities, questions, suggestions, previous agenda items, follow-ups. Okay, then we will move on. We'll now open up to suggestions, follow-ups, articles you've read or like to share, or does anyone have any other member curiosities? I don't believe so. So member input on first drafts of powers and duties work plan.
Yes, thank you.
Mm-hmm.
So as discussed in a previous meeting of the PAC, there is a opportunity for members to give input on a very rough first draft of the powers and duties phase work plan. This is not final. This will be this is designed to evoke feedback from members that can be given to the co-chairs, both the current co-chairs and eventually the powers and duties phase co-chairs, who will be selected by the commission at the next meeting of the commission. And they can develop the actual work plan for the powers and duties phase of work. So this is a preliminary draft designed to evoke feedback. As a reminder, there is a this is the slide we show at the beginning of every meeting that has the phases of work. There is a convening organizational phase that we finished. We are now at the near to the end of the fact-finding phase of work. There are additional phases coming up: powers and duties, structure and details, broader system and other details, and transition plan and final phases. And then the council consideration, which was referenced in a few of our previous discussions that you've had today. We have created flowcharts for the organizational phase. This is one that you probably haven't seen since March. This is the one that we're showing during the meetings during the fact-finding phase. And they show how the subcommittees work together to with the full commission, including full commission work sessions sometimes, to deliver draft documents for the full commission to approve. Quickly to review the agenda and scope definition of what the commission is required to do in the fact-finding phase. And this is requirements of the commission by city council, as well as self-directed deliverables that were then categorized in the agenda and scope into this particular phase of work. How the board can receive and compel testimony, access to records, case handling and investigative processes, including the workflow description. And we've seen several flow charts of the current system and how investigations work during this phase of work as a reference for that. Policy oversight for PPB, including process for policy and training recommendations, and the obligation to respond and follow the decisions and recommendations. That's what is in the agenda and scope, which culminates in 3 specific areas of agreement as outcomes for the phase of work. This is the first phase in which members of the commission will be making preliminary decisions on what the new system will look like. And this is 3 particular groupings of details that the commission will be beginning to figure out. Everything that you've seen, including this slide, is from the agenda and scope document that was approved unanimously by the commission on March 31st. Moving forward, got a couple, this is the part where we start with the rough draft to get your feedback. So the idea is that the Police Accountability Commission is obligated to hear a charter briefing, which, as we've noticed, is tentatively scheduled for October 17th, take briefings and testimony. And we'll come back to this slide in a moment, so we'll move away probably a little too fast, but we'll come back to it. And then 3 subcommittees, each focusing in the same process, but on different subtopics. One on access to information, one on individual accountability, one on structural oversight. All of them would start with open discussions and testimony, continue that while developing and revising a document, and then developing and referring a draft document to the full commission for the full commission's approval. Meanwhile, the full commission would also discuss definitions, which is something that's referenced in several phases of work, but not particularly assigned. And it would culminate with the approval of all of the documents in the December box up here. And then there's the transition tasks to move into the next phase of work as well, but the main outcome finishing is this upper right box. And so to quickly kind of talk about what the key takeaways of that are, having more subcommittees would have more of proportion of the meetings be subcommittee meetings, which means that members who have other obligations would have less numbers of full commission meetings that they would have to attend, and could opt in to work on the various subcommittees. Each subcommittee, unlike this phase of work, would only have 1 outcome document. There is a subcommittee working on 2 different documents. Both the subcommittees and the full PAC can invite briefers and testifiers directly as it relates to their particular area of work. The definitions would be drafted in the full commission. And then I'll just note here, continued coordination on community engagement events. That may be through the full commission or could be through the extension of a subcommittee or creation of a new one focused on community engagement. That's not depicted in the flow chart because it doesn't create a document, But as you'll see at the bottom, there's a little note that there could easily be a subcommittee on community engagement that's not determined yet. So just give a few seconds here for everyone to look at that before coming back and opening it up for questions and then for feedback.
Commissioner Dan.
Hi, I may be having a hard time understanding this, but I'm looking at the three areas that you said that this phase is supposed to look at, which is, you know, access to information, case handling process, and policy changes. Then I'm seeing these subcommittees are on access to information, individual accountability, and structural oversight. So that doesn't match up with the three areas. Is there a reason for that?
There's a couple areas that have developed thematically in the conversation in the fact-finding phase and in conversations around that at the full commission and the subcommittee on research that fit into the latter. But the short answer is looking for a two-word phrase that fits into the slide, into the slide. And you know, noting that we'll have the opportunity for the commission and co-chairs to weigh in on the exact definition of the subcommittees, but specifically why those two words is because the structural oversight piece can also include things that were developed, discussions that have organically developed during the fact-finding phase, such as budgetary oversight, obligation to respond. There is a section, a category on oversight, the oversight board's potential authority to hire and fire staff of the police department, including the chief of police. So those types of things would be that's why structural oversight was used. But there's no, this isn't a final decision. So if you have a preferred, if any member of the commission has a preferred terminology, this would be a really great time. And this will not be the only opportunity. You have others as well.
Commissioner Capron.
I just wanted to follow up to make sure I understand. Are we really talking about accountability at an individual officer level? That's the green thread, and then the yellow thread is really sort of the systematic accountability, how the system is operating, not necessarily, you know, holding individuals accountability, but the system itself, the which is where you get into policy recommendations. Is that a fair way to summarize that breakdown?
Certainly. Yeah, that's a fair way. It's not the only way, but it's definitely a fair way to assess that if that's how the commission wants to interpret that.
Any other questions? Commissioner Dan.
Okay, so I'm looking back at the original document, and what I'm seeing is that part of the individual accountability is in the workflow question includes bureau complaints versus community complaints, which is something that I talked about earlier today. How to impose discipline, including an appeal process, and then mediation options also. So those are all things that we sort of have touched on, but I guess part of my reason I didn't understand that is because the broader description of these categories didn't include those details. Now I understand better now I've looked at the document.
Thank you for working that through, Dan. That helps us as you speak that through. So appreciate that. Any other feedback?
Thank you, Dr. Moses.
Anything else, staff?
I believe the next item is, oh no, I'll pass it over to co-chairs for that. Sorry, thank you.
Yeah.
Getting close. We have another item as we transition. A reminder for folks, at the end of each phase, we'll have an opportunity to potentially review and revise previous documents. So this evening, we want to take a look quickly at some potential revisions from the co-chairs around the agenda and scope document. I'm also aware that it's 9:06 and just want to be really respectful of folks' time. So let's do it and hang in there.
Okay, that sounds great. Thank you so much, Commissioner Faith.
So I'm not going to read through the whole thing because, you know, we've been there. Perhaps let's just go through the track changes. So a lot of the edits have just been clarifications as we've gone further in. So you'll see that we clarified that the intervener is the Portland Police Association. We clarified that we're reporting to City Council on our progress. We clarified Resolution 37527. And one of the additions is in section H here, you'll see outcomes, suggested charter changes to recommend to the Charter Commission, and that this would be something available to us at the end of each phase, rather than just at the end of the organizational phase. So the way that it was written before was IPR/CRC, and so we're just separating those two. Some copy edits similarly, so as well as the Citizen Review Committee, handle police misconduct cases. Now, information from current system on how issues that arise through investigations influence proposals. I'm sorry, interpreters, that I'm going so fast. I will slow down. Overview of different types of oversight systems, including with outside experts. So again, some just copy edits. Changed cities to jurisdictions.
And before we go into section 3, Commissioner Debbie has her hand up.
I was just going to ask about that, suggesting charter changes to the City Charter Commission. You know, they're just about done, and I don't know how much longer that window will be open. So when you said during each phase this is an option, I was thinking I'm not really sure that's true.
Sure.
Staff.
Yeah, just to clarify, and this information might be a week or two out of date, but not more than that. To clarify, the Charter Commission had split its work into 2 phases. The first phase was the conversation around the City Council, as well as the form of government, which resulted in the recommendation to the ballot of the ballot measure that'll be voted on this November. And then other areas of work are essentially all were put into phase 2. And so given ambiguity and lack of knowledge prior to November as to how that ballot measure will be voted on, and knowing that their charge has not yet ended, I believe the Charter Commission gets 2 years to do its work, and it's not finished yet with that time. There are going to be at least a couple more months after the conclusion of this phase of work in which charter amendments could be suggested to the Charter Commission. And the current agenda and scope only has it in the fact-finding phase.
So basically you're adding flexibility here.
That would be accurate.
Yep, thank you. Commissioner Faith.
Any other? I know we're moving so quick. I just want to see if there are other questions or comments on sections 1 and 2, any of those edits from folks.
No other comments.
Okay, let's move to 3. Again, some copy edits, adding and including, re-lettering. We changed the language from paid and unpaid to compensation and support based on what we heard from the CRC around wanting access to some of the city support resources. Added the language board/agency budget. And then in section 5, clarified transition plan and broader system, so that it would not be confusing with the phase above using the word details, structure and details. So are we now at the bottom? Oh, 6. Okay.
Yeah. Yep.
Draft the language of the code change proposal to city council. So again, just changing some language. This is all copy editing, including taking public testimony, etc. So I want to clarify, maybe beyond the copy editing, there's really 3 changes. One, the Charter Commission that we mentioned previously. 2, changing the words paid and unpaid to compensation and support. And 3, changing the name of the final phase of work to broader system versus final details. The rest is copy editing. Are there any questions or thoughts? Have we done enough document review together? I think that's a yes. So do we have to vote on this?
Mm-hmm.
Okay.
Yep.
Does the commission want to accept these changes?
Yep. But so I think we go ahead, Dan. Go ahead.
Well, yeah, there was one thing in the final phase that you didn't read out loud, which was you moved the development of reports to after we voted on the package, or from after we vote on the package to before. And the idea is that we're supposed to develop the package and then write a report saying, encloses our proposed package, and this is how we came to this conclusion, and da, da, da. So I think that should have stayed where it was. If there's some other kind of developing ideas or something like that, or develop preliminary stuff before the final package, that can go there. But the idea of writing a report after the council package is put together, I think actually came from the documents we were assigned by city council, and that's why we wrote it that way.
Thanks, Dan. That's helpful clarification. I'm fine in reverting that. Okay, thank you, staff. And I think I botched it, so I'm going to hand it to you, Dr. Moses.
Okay, so before seeing if there's consensus around approving this document, we're going to hear from the public. After that, we'll ask if members want to make any final tweaks and then ask if they're ready to make a decision. So, yes, are there any comments from the public? I do not see any public comment. So would any members of the commission like to revisit any portion of the document? If there is any strong objection to approving these changes to the PAC scope and agenda, please let us know now. Is there general agreement through a show of hands to these changes to the PAC agenda and scope? I'm seeing hands. Thank you. So I think we can ask for a vote. Does
That was the vote
Mhm.
that you just did.
Okay, we did it. We're done. We've accepted the agenda and scope. Yay.
I just want to say, yeah, we're consensus. So if we have consensus, we don't have to move to a vote. Modified consensus. So there is consensus on the agenda and scope revisions as approved.
Thank you so much, Commissioner Lavisa. All right. The next thing to discuss are very briefly transition tasks and then the garden plot.
So can I jump in on that, Dr. Moses?
Pretty please.
Yeah, so nothing to add on the garden plot when we get there, just to preempt that. But for the transition tasks, that the next meeting of the next full commission meeting, which is tentatively scheduled for September 29th, will be an opportunity for members of the commission to discuss any changes to the other three currently approved documents, the bylaws, internal processes, and community engagement framework. And there'll also be the opportunity, or I guess the on the agenda, to the approval of full commission co-chairs for the powers and duties phase. And then at a later time after that next meeting will be the remaining transition tasks, which include the creation of subcommittees, asking members which subcommittees they'd like to be on, and then eventually approval of the subcommittee co-chairs, which will occur at a full PAC meeting. And I'll pass it over to facilitators for the garden plot.
Thank you. Do we have any garden plot?
Yes, I do have a couple items.
Thank you. Ayamide.
You're welcome. At Commissioner Dan's suggestion, one of the items was, should PAC members be volunteer consultants for the new review board's members for the accountability system? That was one of the major ones that they asked for thumb. And then Commissioner Iona wanted to make sure that there was basically to address the interference of interviews with the PPA, just to make sure that that information is in the document.
Beautiful. Thank you
That's
so
all I
much.
have. Yes.
Thank you, Ayamide. Co-chairs, do you have any additional garden plots? If not, then we are going to move to the end of our meeting. Thank you all who attended today's meeting and for your contributions today. Thank you also to the interpreters supporting access to the meetings of the Police Accountability Commission and its subcommittees for all Portlanders. Thank you to our briefers for coming and spending your time, sharing your thoughts with the commission and the public. Finally, thank you to the members of the community for attending and contributing your thoughts and questions. You can give advanced public comment prior to meetings at tinyurl.com/Portland PAC comment. You can sign up for email updates at the PAC's email at tinyurl.com/Portland PAC updates. It is now 9:20 p.m. and this meeting is adjourned.